Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. And friends, from today's video onwards, we are preparing the video subject wise for the Tamil Nadu Judicial Services, and whatever exam papers we have found from 2018 or 2019, for that we are making subject wise videos. And in today's video, we are going to discuss all the questions of Contract Act from two papers of Tamil Nadu Judicial Services 2018 and 2019. I hope कि ये videos आपके लिए बड़ी useful रहेंगी. So friends, if you are preparing for judicial services, this channel will be very useful for you. आपके लिए बड़ा ही beneficial रहेगा. And अगर आपको ये वीडियो अच्छी लगी हो तो जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ. And don't forget to subscribe the channel. And while subscribing, don't forget to press the bell icon so that you can get the notification of our upcoming videos. And अगर आपको हमारे efforts अच्छे लगे हो तो in addition to like and subscribe, kindly give us a super thanks. Super thanks is a way to appreciate the content creator. आप जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए आप जितना भी अमाउंट चाहें डोनेट कर सकते हैं. मिनिमम इज 40 रुपीज़ एंड मैक्सिमम इज रुपीज़ 10,000. सो डोंट फॉरगेट टू गिव अस अ सुपर थैंक्स. Next, 8. Express contract means a contract made by both words and documents, either spoken or written. A is the answer. Next is 9. The term bailment means delivery of thing entrusted for some special purpose or object upon a contract. Delivery of goods free of cost without cost. No, there must be a cost. Consideration must be there. So some special purpose object upon a contract. A is the answer. And where bailment is mentioned in section 148 Contract Act. Next is 10. Contract is interpreted as an agreement enforceable vide section 2H of the Contract Act. C is the answer. What is 2E? 2E is agreement. 2F is reciprocal promise. And 2I is voidable contract. Next, 11. Consideration in a contract may be past, present or future. A is the answer. Section 2D, definition of consideration. Next, 56. Damages which the contracting parties fix at the time of contract in case of breach is called liquidated damages. B is the answer. Next, 57. General lien under section 171 of Contract Act can be exercised by banker. A is the answer. Next, 58. A person appointed by an agent to act for the principal is called as sub-agent. B is the answer. Next, 59. An agreement to agree in future upon terms to be settled afterward between the parties is not valid. B is the answer. Next is 6. In a case of guarantee, liability of the surety is primary, secondary, or coextensive. Coextensive with that of principal debtors. C is the answer. And where it is mentioned? It is mentioned in section 128 Contract Act. Alright. Next is 7. Sasi and Co., a building contractor, entered into an agreement with Sky Heights Housing Association to furnish a block of 30 flats. This contract was subject to liquidated damages clause if they did not complete the contract on time. Sasi and Co. engaged Lokesh to do carpentry work for an agreed price of 50,000. After 6 months of commencing the work, Lokesh realized that he had priced the job too low and would be unable to complete originally agreed price. Sasi and Co. agreed to make additional payment of 1575 per flat. Now you see there is an alteration in the agreement. Why I'm saying alteration, why not novation? Because he is not doing some else work. So the main nature of the contract has not been changed, only the price, additional price is there. So this is an addition in way of alteration. Lokesh worked for a further period of 6 weeks but only received additional amount of rupees 1,000. He then ran out of the money and refused to continue unless payment was made. Sasi and Co. engaged another carpenter to complete the work and refused to pay the Lokesh for further sums. So this is wrong. They should pay him. Answer options are: the agreement to pay extra was unenforceable as there was no consideration for the subsequent agreement. There is no requirement that, because that is only an alteration, not an new contract. Then B is consideration was provided by the location in form of conferring a benefit on the Sasi and Co by helping them to avoid penalty clause. Yes, it is correct. Therefore, Sasi and Co was liable to make extra payment promised. Yes, it is correct. Next, C है फिर the concession provided by the location as over penalty clause was not main object of contract. Therefore, अब now here they are denying not, then they are saying it is the reason. No, it is not correct. Then liable to pay consider as they have committed a breach of contract by employing another carpenter. No, this is wrong. B is the answer. Next is 8. What is continuing guarantee? Guarantee which extend to series of transactions. C is the answer, and where it is mentioned in section 129 of Contract Act. Next is 9. A wanted to sell his house to B and made an offer by email to sell his house at 65 lakhs. On the same day, without knowledge of A's email, B sent an email to A informing him that he would like to buy the house for 65 lakh. Identify the correct statement. The contract is valid as both offer and acceptance has been no. Both parties have agreed upon no. Invalid as there is no acceptance. C is the answer. कैसे? How? Because this is a cross offer and nobody has given any acceptance to each other. C is the answer. Next is 10. Statement A. A surety discharged from his liability under a contract guarantee is the creditor does or omit to do something that results in impairment of remedy available to the guarantor against the principal. This is correct. Statement B is the guarantor is invested with all the rights which the creditor had against the principal debtor after due payment and performance by him on the behalf of principal debtor on his default. This is also correct. Both are correct, and B is the reason for statement A. C is the answer. Next is 11. Which of the following is not true in respect of contract of pledge? Pawnee cannot retain the goods for recovering extraordinary expenses. This is correct. Then B. A pawnee can exercise the right of lien and right to sue simultaneously. This is also correct. Pawnee may sell the goods on default by the pawner without giving notice. No, this is wrong. Notice is important. This is not true. C is the answer. Pawnee has security interest which enforce even against the state. Yes. Yes, this is also correct. So C is the answer. C is not true. And this is mentioned in section 176 of Contract Act that a reasonable notice of sale shall be given to the pawner. Next is 12. If the promisee accepts an anticipatory breach committed by the promiser, then he need not to perform the part of the contract, but he can claim. He need not. ठीक है, must perform तो हो गया wrong. So these three are the options. He can claim damages for the promiser only after date of performance. No. Without waiting till the date of performance. C is the answer. Section is 39. Can you tell any case on anticipatory breach? Avery versus Bowden and Hochester versus De La Tour. Have you heard of these cases? If not, then just look at these cases. Next 43. Why a famous Hollywood celebrity has won huge amount of damages for defamation against a well-known newspaper? When questioned by reporters on the impact of awarding such huge damages on the freedom of speech and expression, whether such huge damages justify the injury and compensation, Why replied that damages should not only be seen as compensation economic loss, but as an example to the other that reputation of a person is invaluable and should not be tampered with. This kind of damage being referred by Y are known as exemplary damages. Means damages which set an example for the general public that nobody shall do that again. So B is the answer. Next 56. In case sub-agent lawfully appointed, which of the following is correct? As regard third party, sub-agent can neither bind principal nor sub-agent binds principal as an original agent can bind. C is the answer. Section is 192 of Contract Act. Next 57. Which of the following statement is not correct? When the acceptance is required by post but the same is made by telephone and email, it is valid contract because it can reach the proposer before the post, so it can be valid. B. If the deviation from the prescribed manner is to disadvantage of the offerer, he is entitled to treat the acceptance as invalid. It is correct. If the offerer wants the acceptance to send by wagon but the same is sent by post, the letter reaches after the arrival of the wagon, the offerer is entitled to treat the acceptance as invalid. It is correct. This is the case So you can mention the name of the case in the comment section. I will mention it out later on if nobody answers in a week. And D is the communication acceptance is complete as against the proposer as soon as the acceptor puts the post in the transmission. So this is wrong when it comes to the knowledge. So D is the answer where it is mentioned in section 4 of Contract Act. Next is 58. The juristic concept of the contract consists of agreement and obligation. D is the answer. This is a repeat question. I have seen this in Bihar judiciary papers. You can see that. Next 59. The latest theory of contract is theory of enforceability. B is the answer. Next 60. To sell a thing by a finder under section 169 of Indian Contract Act when the owner refuses to pay the lawful charge upon demand. What is the lawful charge of the finder? That is 2/3 of this value. It is mentioned in subsection 2 of 169. D is the answer. Next 61. A took his wife B to England for vacation due to some business emergency. A had to go back to his place of work immediately while leaving B in England due to her ill health. A promised to pay £300 per week as maintenance during her stay in England but failed to pay. If A is sued by B, then whether A is liable? No, A is not liable. Why? Because there is no intention to enter into a contract with his wife. B is the answer. And this is a famous case. I will write the initial B versus B. You can just comment in the comment section the name of the case. Next 62. Now you have to match remoteness of damages, that is Hagdale versus Baxendale, liability for fraud, Derry versus Peak, concept of unjust enrichment, Moses versus McFarlane, communication of acceptance, Adam versus Lindsay. So this is 2, 3, 4, 1. A is the answer. And if you know that Moses versus McFarlane is on unjust enrichment, then you can just answer it because 4 for the C is in only one option here. Otherwise, other options are 2 or 3 in number. So friends, here we have discussed all the questions of Contract Act from 2 papers of Tamil Nadu Judicial Services 2018 and 2019. अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, कोई कमेंट्स हो, तो आप जो है कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स. एंड अगर आपको ये वीडियो अच्छी लगी और एफर्ट्स हमारे अच्छे लगे हो तो उसको ज़रूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ, सो दैट दे कैन कम टू नो अबाउट आवर चैनल एंड वो भी बेनिफिट ले सकें. एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो इन एडिशन टू लाइक एंड सब्सक्राइब काइंडली गिव अस अ सुपर थैंक्स. सुपर थैंक्स इज अ वे टू अप्रिशिएट द कंटेंट क्रिएटर. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए कोई भी अमाउंट जो है डोनेट कर सकते हैं. फ्रॉम मिनिमम स्टार्ट्स विद 40 रुपीज़ एंड मैक्सिमम टू 10,000 रुपीज़. तो काइंडली गिव अस अ सुपर थैंक्स. So friends, thanks very much for watching this video. Thank you.